Okay, welcome everybody to today's webinar and where we'll be discussing the concept of winding up self-managed superannuation funds. So this is a presentation that I try to sort of refresh every couple of years, just because there's always some slight changes to the way that the tax office do things, and obviously then there's obviously a lot of other sort of legislative issues that raise their head, that make us sort of contemplate whether or not a self-managed super fund is the appropriate vehicle of choice for our clients. And so really today what I want to focus on with you all is really just some of the key influences for the SMSF wind up decision making process. So I want to spend a bit of time working through a number of those key issues throughout. Then we'll sort of touch on or sort of work through the process itself, sort of what I consider the 12-step stages to winding up a fund, and finish off just by ultimately providing you with a bit of a checklist that you can utilize for your clients, and also some ATO resources which are a little bit more comprehensive again, comparative to the checklist that I provide with regards to the wind up process. So yeah, really it's a little bit about some of the practicalities associated with winding up a self-managed superannuation fund, but also then some of the technical things that we have to consider along the way as well. So what I wanted to start with, and I always like to sort of address these issues sort of up front to give us a bit of an idea as to what we're looking at from an SMSF point of view, and appreciating that I'm providing this webinar today on behalf, obviously, of myself from Smarter SMSF, but working in conjunction with SuperGuardian, and appreciating that some of these numbers are a little bit skewed in the sense that a group like SuperGuardian would obviously engage in far more wind-ups, and so ultimately it would bring the average number of wind-ups down per practitioner or per tax agent point of view, because you have these large administration firms that would deal with a lot of the wind-ups as they go along. But what we've seen statistically from the tax office is that in the 21-22 year, we actually saw a quite a significant drop in the sense of the number of wind-ups. Because if you look at the 21-20, the 19-20, and the 18-19 year, all of the average numbers was around that 17,500 wind-ups per year. So then to drop by about 3,000 kind of almost suggests that, well, firstly, when you look at net establishments, the 21-22 year was quite positive from a numbers point of view comparative to the others. But also, you know, in light of a lot of the 2017 super reform, it's almost that the majority of the wind-ups that needed to be done have now been done, and we're sort of getting back to numbers more what I would consider aligned with the history of self-managed superannuation funds, which is, you know, that sort of between 13,500 to 14,500 a year from a comparative point of view. Now, what was interesting from a statistical point is the age of these funds that are being wound up. So most of the funds on average have been in existence for 13 years. So it's not that these funds are you know, quickly established and quickly wound up. And I also suspect that in these wind up numbers, you know, there would be an element of funds that the ATO don't count because these funds have never lodged in the first instance. So where we've talked previously about illegal early release and other things like that, where the ATO have a real issue with first year funds being set up exclusively to access superannuation illegally, I suspect that a lot of that isn't incorporated into the appropriate wind up numbers. But as you can see there, with our average number, or with our number of tax agents at 13,800, it basically means that most tax agents that are lodging are probably lodging only maybe one wind up a year. And so, you know, it's that whole freshness of process of understanding what's required to wind up a fund if you're not necessarily undertaking wind ups on a regular basis that I ultimately want to address here. The other statistic of that is that 99% of self-managed super funds, again from that same statistical overview from the ATO, 99% of self-managed superannuation funds do lodge via a tax agent, and so this is ultimately representative of the appropriate numbers. What I found more interesting, and this stat has been provided for a number of years, but it's not one that's necessarily taken my interest so much until really putting this presentation together for you today, and that is the phase where people are winding up superannuation funds. So we can see that it's close to 60%. So almost 3 in 5 wind ups are funds that are in the accumulation phase. And we're not talking about small balances there either. So we're talking about, obviously, from a medium point of view, $230,000, 410 from an average point. But of course, with so many significant balance funds, that's obviously going to implicate or going to increase that average balance there. But that's still sizable. 230,000 is the halfway point of the number of funds from an accumulation point that are winding up. So this is how much money they have in their super in the year before the wind up, meaning that there's got to be some activity with regards to the redemption of investments or whatever it might be, and clearly a sizable amount of money that needs to be rolled over. So that's obviously a key thing that I picked up out of these stats. And then when we look at the retirement numbers, it's not so unusual to see larger numbers there, because there can be all sorts of reasons, and I'm going to touch on a number of those reasons as we go through today, with regards to why we might look at winding up a self-managed super fund when we're in the retirement phase. Generally, the primary issue is going to be is that maybe one more dominant member of the fund has passed away, and the other member is not interested in keeping the self-managed super fund, and that's quite a legitimate reason for the fund to be wound up. So again, what I really want to focus on with a lot of these things today is really addressing sort of where there are alternatives, what are those alternatives, and where there's no alternative, where the decision is made to make the choice to wind up a self-managed super fund, that the fund then goes through the correct process to get that done. And so really, I guess what those statistics are showing is that throughout our superannuation life cycle, and if we break that down into the accumulation, transition to retirement, and then the estate planning piece, we will see wind-ups happening along the entirety of that life cycle, and understanding and appreciating what clients need to do at each stage is going to be important to ensure that the funds that are sitting in this wind-up sort of sphere don't end up fitting into that illegal early access sphere of funds that have inappropriately taken money out of the superannuation system. So it's really kind of a key issue to be mindful there. And probably the most significant, I guess, change in the last time since I've been doing these presentations on winding up self-managed super fund, probably from the last cycle of when I did it, the most significant change that's occurred in the SMSF space is effectively the super stream requirements that came into play from basically the end of 2021, and how they impact self-managed superannuation funds from a wind-up point of view. And I think when we look at the super stream requirements, and I'm not going to spend a great deal of time talking about superstream, but just highlighting a couple of the issues that superstream has ultimately created within the superannuation environment that we need to be mindful of. And when I for me, a lot of this came about when I was working at SuperGuardian, and we were dealing with a number of funds that were being wound up. We came across issues where the tax office had cancelled the ABN, so we'd actually lodged the final return for the fund, and then the ATO were cancelling the ABN, and they were doing it. They were saying they were doing it within 14 days, but often within that 14-day period, the refund had come back from the ATO for the final return, but then there was an inability to actually process the superstream rollover because the ABN had been cancelled, and then with that ABN being cancelled, you couldn't go through the process. So could be no verification. The fund wasn't on the lookup system, and so APRA funds weren't able to accept the money. And it then sort of led us down a path. So I was working quite closely with a number of the client managers at SuperGuardian. It led us down the path of communicating with the tax office about what the options were, and ultimately in that instance, the primary the primary position that they were coming back with was that, well, there was a number of things, but one of them was that you had to apply for specific fund advice to get a resolution from the ATO, which seemed an illogical approach. But the longest process was that they could, in certain circumstances, reinstate the ABN, but that was then going to delay the rollover process even longer. And so, it started with me whilst I was at SuperGuardian, and then when I moved across to Smarter SMSF, we continued the conversation with the tax office. And what we saw through not only our work, but the work of others within the industry, we saw the tax office expanding that cancellation of the ABN from 14 days through to 28 days, which ultimately gives funds that little bit more time, gives them that month to be able to finalize that final rollover, which hopefully in most instances is for a small amount that's a result from the final refund that's come in from the ATO in most instances. And so I guess probably the first point of interest that I would highlight there is that if we're looking at doing rollovers and we have to roll the money over, so we haven't met a condition of release and can't pay the benefit out, then ultimately we need to try and roll over as much as we can with that first initial rollover under the super stream requirements, so that any final rollover amount is negligible, and primarily that it's negligible from the point of view that it doesn't become an ACR issue from an audit report. It might just become a management issue in regards to not rolling the money out in time. If it's a small amount, then the auditor is less likely to report it from an ACR point of view. But the other thing that came about from all that was that the ATO did previously provide temporary relief, so it did provide relief for funds to be able to use the paper rollover forms. But a lot of that had to do with the electronic service addresses and not enough providers out there. But the ATO changed their position on that midway through last year, so effectively from the 30th of June last year. You must use SuperStream. Now, of course, there are exceptions to SuperStream, and one of those exceptions is things like in-specie transfers. And that's an interesting comment, and I'll highlight a few of these points sort of as we go through the presentation anyhow. But it was only last week that I actually had a question, and so this sort of triggered me in regards to coming here and talking to you today about this issue, the sort of questions that I'm still getting sort of in practice with regards to a lot of these issues, and these are commonly asked. And so, whilst for me, I might look at it and go, that surely we all know the answer to that issue, but clearly there are people out there that don't. And so appreciating that things such as in-specie rollovers, because I had a question about someone that wanted to wind up their self-managed super fund, and they wanted to transfer the assets to a retail provider. It was a platform provider, and the transfer to that retail platform provider allowed them to retain the assets that were held by the self-managed superannuation fund, which is great. But two accountants linked to the client had indicated that there was no CGT associated. Now, these people were in accumulation, so they weren't in pension phase, that they had indicated there was no CGT attached to the in-specie transfer of the assets from the self-managed super fund to outside of the self-managed fund, to either the individuals themselves or to another superannuation provider. Now, I clarified that point for that particular advisor to say, well, absolutely, there is a CGT event there. So there is a beneficial change in ownership, because there's historical cases that identify that in the SMSF space particularly, because you have estate planning and the opportunities that the beneficiaries aren't necessarily known up front, that you can't convincingly argue that there's no beneficial change in ownership. So one of the key points that I would highlight from today is that whether or not you're doing a cash rollover or a shares rollover, that CGT will apply if those assets are held in an accumulation phase. So let's start to work through some of the key, I guess, considerations that I would be addressing when it comes to the concept of winding up a superannuation fund. And a lot of these are points that ultimately have been the position for many years. And then some of them, I guess, we now have to contemplate in light of of new issues. So one of those, I guess, ultimate new issues is going to be the concept of Div 296 and this whole $3 million balance. Now, this is an interesting area because, I've been doing a roadshow. I did a roadshow throughout March, and we posed the question to attendees, how many of your SMSF clients have indicated that they may consider winding up their self-managed superannuation fund because of the introduction of Division 296 and the additional 15% tax. And I was actually quite staggered to see how many people were contemplating it. Now, again, we don't want people to jump the gun with regards to legislation like that as to what it might ultimately result in. But, certainly from an advice point of view, from a taxation point of view, we really need to be clear to people what the taxation outcome is going to be by retaining money in super versus pulling that money out of super. And we don't want people to jump the gun and necessarily wind up superannuation funds too early. However, what this whole Div 296 has really started to clearly define is that there is most definitely an issue in our industry around death benefit tax. And this, again, many of you would have heard from me historically always talking about when we're dealing with death benefits, how we have a first death benefit in most funds. So 80% of self-managed super funds are couple-based funds, two-member funds, where you'll have the first death benefit largely paid to a tax dependent, and then that second death benefit paid to a non-tax dependent. And so I think we will get to a stage where, from a wind-up process, that more people are trying to act sort of as late in life as possible pre-death to ensure that they minimize tax on those death benefits. And that of course, is an entirely separate subject to what we're talking about today, but it comes into the thought process around winding up a self-managed superannuation fund. So some of the things, and this goes back many years to the ATO's resources, like understanding what your trustee responsibilities are. So do you have a good knowledge of your responsibilities and obligations? Of course, anyone can sign a trustee declaration, but can they sign a trustee declaration with the knowledge that they understand all their responsibilities? Have they got the time to run a self-managed superannuation fund? So is it appropriate for them to have one? Are the costs more than they want to pay? Or would it be cheaper to hold their investments inside a retail or an industry fund? Are they able to continue managing the fund's investments effectively, or they get higher returns if the super was managed in another type of fund? And again, this often comes down, probably one of the things that we see the most is whenever there is a market event where the stock market crashes, we actually see a lot of people jump into self-managed super funds at that time. I mean, statistically, you can look at a lot of the fund establishment historical records there, and you see a bit of a spike when there's global events. And a lot of the time when you actually go out in the cold face and talk to people, they say, well, we can do better than the other funds. And what they're effectively saying is that they can do better than the professional investment managers out there, which I think in many instances is misguided opinion of themselves ultimately, and whether or not they're ultimately going to get the best outcome for the super fund. And of course, some people will do better, but I suspect that quite a lot ultimately won't do better there. And I think probably the biggest one, and to me, this is almost the quintessential point as to whether or not people should have a self-managed superannuation fund, and that is, do they still want the responsibility of running the fund? So do they really want to take on that obligation and the potential pitfalls associated with that? And that comes back to that point I was making before about where the dominant member passes away. Was the other member in the fund, in a two-member fund, were they only there because they were convinced it was the right thing? And if that member passes away, do they then particularly want to have that ongoing responsibility? And I think, particularly in light of the fact that we're now at 6-member superannuation funds, not that we see a lot of 6-member superannuation funds, but do all trustees still agree on how to manage the fund? So, has there been a falling out or some form of relationship breakdown? And I'm going to touch on relationship breakdowns and give you a bit of an example through the presentation from purely a separation or divorce situation there. But of course, relationship breakdowns can take all kinds of form, and the one that I see quite regularly when you're talking about self-managed super funds is siblings and sibling falls out, sibling rivalries. They obviously have got spousal situations, but and then business partners breaking down. But generally, you've got to factor in all the issues associated with those things to determine whether or not the self-managed super fund is suitable. Which then leads us to some of the reasons why a self-managed super fund might be wound up. So we can go through, and I always try to look at this in a relatively balanced position to say, okay, well, there's pros and cons either ways, and the same thing can be said for setting up a superannuation fund. But then we've got to try and find that tipping point for each fund to determine whether or not it is appropriate for that fund to continue. So things such as the trustee capacity to manage the fund has deteriorated, and again, it might be based on age, but it could also, of course, be based on incapacity. And I think incapacity, this is an area that we've been talking about from an industry for quite some time now, and particularly the area around elder abuse. If we're talking about the loss of capacity, then clearly we're identifying that someone can still be a member of a superannuation fund if they've lost capacity, but then who is going to act in their place as the trustee? And does that enduring power of attorney, or that court-appointed person, whoever it might actually be, who represents them as their legal personal rep, does that person have the desire and the capacity to act as trustee of the fund? And I wonder, and I've always wondered, how many people who do things like go and prepare their wills and go and prepare their enduring powers of attorney, how many people in that set of circumstances, actually speak to the people that they're giving those powers to and say, do you understand that I have a self-managed superannuation fund? And are you willing to take on the responsibility as the trustee of that fund if I lose my my capacity? So that's obviously one reason why a fund might wind up. Of course, the other one is the fund has paid the member benefits and the capital has been exhausted. So again, we've reached a certain age where we needed the money for whatever reason, drawing down a pension, and we're out of money. So do we wind up the fund there? All the members have left the SMSF by rolling their benefits into another fund, or they've passed away. So similar to the funds being exhausted, certain events have triggered the benefits being paid out of the fund. One or more of the trustees have relocated overseas and no longer meet the definition of Australian super fund. So I'm going to touch on that Australian super fund definition in a moment. And then there are insufficient funds remaining, meaning it's no longer cost effective. And I think that's obviously becomes a critical one. But to me, you're almost sort of saying that the ones in the middle there, the balance-driven ones about the member decisions, there's always going to be options there as well, but it's the two extremes there, the loss of capacity and the cost effectiveness. It's what sort of options do we have in that regard, and do APRA funds, are they fit for purpose in that space as well? So, and again, a lot of that's going to come down to the existing investments of the fund and whether or not that can be mimicked or managed to a reasonable appreciation in an external product. So we have to look at a number of those key issues. And so what I try to do is I try to identify, okay, well, when contemplating whether to keep self-managed super fund or contemplating whether to wind up a self-managed superannuation fund, there are a number of flags, and they're largely timing-based flags that we have to actually contemplate. Now, I sort of have tried to break these into investment based decisions and then member-based decisions to try and identify some of the key issues before I go through a couple of them with a little bit more detail. But clearly one of the big ones is the CGT position. So taxation obviously plays a large part in a lot of people's decision-making process, particularly when we're talking about the wealth attached with members inside a self-managed superannuation fund. So having a good appreciation for what the ramifications are of having to sell down the investments of the fund, right, and then ultimately triggering any capital gain. Now, I jump back to that question that I had last week about the in-specie transfer, and I said that the members were in accumulation and they wanted to transfer the shares out of the fund. Now, they were looking at some part of it to be a rollover to a fund because they were in accumulation. However, these people had actually met a condition of release, so they're over 65, but because they had sufficient income on the outside, they didn't want to draw down on the income of the super fund. So they could inevitably commence a pension and then look to in specie those assets out. So, you know, what conditions inside the fund can be met to potentially offset the taxation liability. So do we have the capacity to go into retirement phase and then offset the CGT position of the fund? So that's one of the discussions to be had. Carried forward realised losses and carried forward tax losses. You know, so what often we see the situation where, again, if the market has deteriorated for whatever purpose, and the decision is made at that point in time, because the markets are dropping, people go, I can't handle having a self-managed superannuation fund anymore, and so they actually sell at the worst possible time, and they ultimately create these carry forward losses that are ultimately pointless and don't provide any benefit. And so, you know, the concept of whether it's worth riding the wave, because particularly if it's in accumulation, realizing those losses in the SMSF and then rolling that money over into an APRA fund and then acquiring investments, you know, where the CGT is going to be dispersed across all of the members of that fund, you know, you're going to lose that benefit. So is it the appropriate thing to do at that point in time? And the same with carry forward tax losses. And I think probably what I would highlight there as being one of the key points is one of the deductions that many of you would have heard me talk about, if you've listened to anything I've done on death benefits and insurance inside super, is the future liability to pay a benefit deduction. Now, this is the deduction based to claiming on the future portion of a benefit payment if a member has died or received a disability benefit prior to age 65. You can claim a deduction based on the future portion of the entirety of the lump sum or pension commencement. And so if we're seeing members of the fund pass away, and we're able to claim this future liability deduction, then in most instances that is going to create a tax loss, and a significant tax loss for the superannuation fund. Now, that tax loss is going to be utilised to offset contributions tax and other things, as well as capital gains along the way. So very beneficial. So to wind up a self-managed super fund, and you take the death of a member, for example, take the death of a member where they're under 65, and the other member looks and says, well, you know, I don't want to manage the fund anymore. Well, if they've got access to this future liability deduction inside the SMSF, then by retaining the fund, they may be able to offset contributions tax for X number of future years, which could be significant. I mean, I had a situation about 3 weeks ago with a client who had a $2 million insurance payout. They'd passed away at age 51. So they've got 14 years of future service period. And ultimately, of that $2 million, they only had a balance of a couple of $100,000 in their self-managed superannuation fund. But the total benefit payment was going to be $2.2 million. The future service deduction based on their service period was going to be a tax deduction of $800,000 if they were eligible to claim it. Now, that $800,000 for their spouse who was the same age, at 50 years of age, would suggest that that spouse would never pay tax on contributions again, because they're not going to make $800,000 worth of capital gains or contributions over the next sort of 15 years. And if they do, it's going to be at the tail end, potentially where they can look at moving into pension phase. So, you know, the loss of tax losses is certainly a significant one if you've got them inside the super fund. And then other issues associated, obviously, with delisted shares and frozen assets, and the intricacies of trying to transfer those out of a fund from a wind-up point of view. That's always problematic. They've been problematic for 20 years dealing with those sorts of transactions, and there's no right or wrong way of dealing with it. But if you're going to find a way, if you're going to try and transfer those assets out of the fund, then you need to either, in accumulation, you need to find someone that's going to accept them, or you potentially look to purchase them directly. So the members look to purchase them directly. Then how do you establish what is the arm's length value of those shares to ensure that you don't trigger any gnarly in the fund? Now, of course, in many instances, the value will be nil. So that takes care of itself. And then beyond that, and probably the biggest one that we come across or are confronted with, is the issues associated with winding up a fund that's holding property, and the appropriate transaction costs and time that's involved in selling down the property there. And you know, when I look back at the funds that I've administered over my journey, and you know, I had a fund where we had a disqualified person, which is on the next column there, and so they had to leave the fund. But the fund basically had primarily property investments. And so it actually took sort of a year and a half to sell down those investments, which meant that there was an ongoing communication requirement with the ATO because the fund wasn't meeting the definition of a self-managed super fund, because you had a member who wasn't the trustee, because their benefit wasn't able to be paid out until they were able to liquidate appropriate amount of the investments that the fund held. And that sort of takes us over to our member-related flags when it comes to wind-ups. And to me, the key one, obviously, as I highlighted before, and I'll go more depth on the relationship breakdown in a moment, that's a flag. Obviously, the death of a member creates all sorts of things from a consideration point of view in the SMSF. If we've got a member passing away, what sort of time stands still in many instances, and what does that mean from a processing point of view? What does it create from a longevity in keeping the fund open? But also, is there a purpose, or is there a benefit in keeping the fund open for longer in those circumstances? Our non-commutable income streams, so our term life, our lifetime pensions, and our market-linked pensions, these legacy items from pre-2006 that are still in the SMSF environment, they are problematic when it comes to the concept of winding up superannuation funds. And people don't necessarily understand the ramifications linked to them. And so people need to really sort of have clarity as to why they need to have those funds. But importantly, if they've got a lifetime pension or a fixed term pension, then the ramifications of potentially having reserves inside the funds and what that actually means, because you might have no members with any balances in there, but you've got these reserves created from these legacy pensions. Now, I was blown away last week. I had a query from a client who still had a term life pension. So they started this pension just before 2006, and also I think it must have been a 2004, 2005 pension, and the term of the pension doesn't expire until the end of this year or the start of next year, and it was like, wow, I thought all of these had disappeared, but the fund value is not what the member thinks it is, because their member balance is negligible, but there's a couple of $100,000 sitting in there in reserves, and this fund has to find a way to deal with those reserves. UK pension. So anyone that's got money across from the UK, you can't just wind up the self-managed superannuation fund, because there might be ramifications subject to the size of the balance. You have to make sure that you're in reasonable enough communication with the UK system to make sure you're not breaching any issues. And you certainly can't just roll the money over to another fund, because if that fund is not a QROPS fund itself, then there's going to be additional tax and charges associated with that. And then there's a disqualified persons bit, which I highlighted before, and I'm going to touch on that as we go through. So I just want to sort of work through a couple of the key issues before I sort of finalize on the process and the checklist elements that we need to take into consideration. And non-residency is clearly one where there's a suggested path to I guess a suggested path to not having a self-managed superannuation fund. So if you fail to meet the definition of an Australian super fund because you are no longer present in Australia, so you're unable to make decisions physically in Australia, and effectively, let's say you've moved across for tax purposes to another country as well, so you are not a resident of Australia for tax purposes, then you're potentially looking at failing two of the three definition requirements for an Australian super fund: the central management and control test and the active member test. Now, in the sense of how we resolve this, it's quite easy to satisfy the central management and control test. And again, that can be done through the appointment of an enduring power of attorney to replace the trustee that's overseas to make the decision, or by the addition of other members. So by adding more members to the fund, if two members are overseas and you've got two members in Australia, then the central management and control and tax ruling, that's 2008/9, don't quote me on that one, but the ATO ruling about the definition of Australian super fund does highlight that if you've got 50% of trustees in Australia and 50% overseas, and they're equally involved in the decision-making process, then the central management and control would remain in Australia. So you've got opportunities, you've got options to solve that one. The contribution issue, which is the active member test, that is obviously problematic. Now, it's only problematic whilst the law exists as it currently does. we're still waiting. 3 years later now, we're still waiting on the government to act on the removal of the active member test from the income tax legislation. We hope that this occurs, because that cleans up a lot of this space. They're also going to potentially extend the central management and control absentee period from 2 years to 5, but the active member test is the real kicker. So the removal of the active member test would mean that people could reside overseas and still contribute to super and not fail the definition of an Australian superannuation fund. So again, you don't want to act in haste with regards to winding up a fund because somebody is moving overseas if you haven't explored all the alternatives before you go down that path. And I said, I'm going to come back and talk about small APRA funds shortly when I talk about disqualification. So again, there are the phase considerations. So whether we're in accumulation or retirement phase, they raise their own issues. Those in accumulation, we have to roll the money over to another superannuation fund, and that's what's going to trigger potentially the CGT liability. So we have to be aware of our own circumstance or our fund's circumstances and how to handle it. Transition to retirement income stream, they're not in the retirement phase, so we have to treat them like accumulation interests unless we can trigger another condition of release. Now, of course, we're getting closer to that with preservation moving to age 60 from the 1st of July. The definition of retirement is quite significant, because it's, you've got to have a future intention declaration made if you're under 60 previously. But once you hit 60, you can make that future intention declaration that you have retired with no intention of re-entering the workforce. But there's also the second arm of the retirement definition post age 60, where if you cease gainful employment with an employer who has contributed after you turn 60, then you can trigger the retirement definition. So again, from a TRIS point of view, there are some key issues to be mindful of there. But then, of course, the other things that I touched on before, when we move into the retirement phase, things like those market-linked lifetime and term pensions being non-commutable, where are you going to take them? Where are you actually going to move those pensions to? What other service providers are out there? Is it better for the fund to contemplate retaining the existing pension within the fund for however many years are left, right? Or are we better waiting and seeing if we're actually going to get this legacy pension amnesty, right, rather than looking to go and commute and roll over somewhere else and then not have that amnesty available to us? Will this amnesty come in, and are there better alternatives there? But often we're going to be potentially stuck with this SMSF until the term expires. And I would say that anyone that's still got lifetime pensions, and the primary reason they've got it is because the clients like the 100% asset test exemption, right? They then really do have to start to weigh up now. I think that we're getting, into 2024, 25 type timeframe, and these clients are getting into their mid to late 80s, if not into their 90s already. From a simplicity point of view, should they be looking at commuting their pensions and moving from lifetimes to market-linked pensions, even inside the self-managed superannuation fund? But also, in a more practical sense, if we're looking to wind up the fund, have we met all of our standard conditions? So have we ensured that we've paid the pro rata minimum pension requirement? If we do commute a lifetime pension, what were the terms? Did we have to make monthly payments? Have we made those monthly payments before the pension is commuted? And then for those clients who have got Commonwealth Seniors Health Card or the age pension, moving from one provider, being the self-managed super fund, if they're moving it to another super provider, so if they're not taking the money out, but they're rolling over their pension, well, then they will lose their grandfathering that was attached to their pre-2015 pensions, which means, potentially from an age pension, it probably has less ramifications, deductible amount versus deeming, whilst deeming is so low. But from a Commonwealth Seniors Health Card, where it goes from an asset test pension, so the account-based pensions pre-2015 are asset test exempt, so they're not counted, to being deemed from an income point of view. So that could have ramifications on the Commonwealth Seniors Health Card. So again, clients have to look at that and the importance and the value that they associate with that. From a relationship breakdown, probably what I wanted to highlight, and I've got a bit of an example that I wanted to show you, and it's just really about the final dot point there. there is legislative provisions built into the SIS Act and the Tax Act with regards to CGT relief, certainly. So the CGT relief for small funds, small super funds, for rolling and splitting benefits to another the super fund. But then there's also acquisition of assets from related party relief to allow us to transfer assets from one fund to another. So if one fund leaves and moves to another self-managed super fund, we do have the capacity to deal with that situation. But it's also a little bit about thinking outside the square and what opportunities might present themselves for a superannuation fund. Now, I'm just gonna put a further disclaimer in addition to the one that I start with up the top, and appreciating that I suspect that this example, from a pure lending point of view, is unlikely to work because you can't lend. There's the 1322C element here, so it might actually work if you've got the funding. What I was meant to say is I appreciate that in a relationship breakdown, you probably don't have the funding to be able to lend the money to a superannuation fund. But if we look at this Adam and Eve fund, and they run a small business, and the SMSF holds the business property, and there is a requirement to transfer money. So in this instance, we need to transfer $500,000 to Eve. Then what we can look at doing is going, okay, well, how can we, if the decision is made that we want to retain the business real property, for example, inside the super fund, so the parties agree to doing something like that, then how can we do that, and how can we make that benefit payment? How can we effectively split the property without creating an issue for the fund? And again, this comes back to the whole idea of, if we look at how properties are acquired in the first place, then the capacity, if we've utilized things such as 1322C structures to acquire property in the first place, then we could look at conceivably a strategy like this, where the self-managed super fund, so we have the fund, we've got Adam, we've got Eve, we've got $500,000, we've got the property sitting inside a 1322C unit trust. Appreciate that this is unrealistic in that this is the only investment of the fund, but this is more conceptual from a point of view. We know that we have to pay Eve out that $500,000. So what we do is the super fund effectively borrows to acquire the property via a limited recourse borrowing arrangement. So it buys the money, or buys the investment from the 1322C. The 1322C proceeds can then be distributed, and the distribution can obviously assist in the cash transfer payment to Eve, and the fund then sits in a situation where it ultimately owns that property no longer via 1322C, but more so directly, and utilizes the holding trust. So instead of it being Adam and half a property, we've still got $1 million property, but we've got a $500,000 loan. Now, lots of logistical issues associated with that. I appreciate that. But really what I'm saying is that we can look outside the square to work out, are there ways for clients to be able to retain particular assets or undertake certain transactions in the event that we've got a relationship breakdown. So, because if we had to wind up this fund, then there's a lot of other potential issues associated with transferring the property out of the super environment and other things as well. So, let's explore all avenues before going down that particular path. So the disqualified person is probably the last sort of key consideration that I want to bring to before we work through the process piece of the wind up to bring the webinar to a close. What we understand and what we know here from a legislative point of view is that if you're a disqualified person, then you must resign immediately. So you can no longer be trustee of the fund. Just as importantly, your legal personal representative can't be the trustee of the fund either. So in a lot of those circumstances, there's going to be an expectation to wind up the self-managed superannuation fund, because if the bankrupt member is the primary member, then it may not be, it might not be feasible to retain the superannuation fund. It could be a single member fund. So we have to look at what our options are. But there might be investments inside that fund that dictate that we'd actually want to look at retaining the fund. It might be commercial property, and we don't want to transfer that investment out of the super environment, potentially have it come form part of our estate from a bankruptcy point of view. So there's a few things to contemplate there. And so what I wanted to, I guess, touch on, and it's an area that that I know that I've certainly spoken about at great lengths, but it's kind of, I still feel that it's an undervalued process, in the sense that I don't think the government have ever really spent enough time at looking at the value and the value proposition of small APRA funds, in the sense that they 100% serve a purpose, but from a compliance point of view, that purpose is made too difficult because of the reporting obligations, by treating them almost like a large APRA fund. So because of the extensive reporting obligations attached with being a small APRA fund, which by every other measure is the same as a self-managed super fund, other than it has a professional trustee, it's resulted in this point where you see in that last little dot point there that as of the December APRA stats, there are only 1,200 small APRA funds remaining. So it's a very, very small market of the entire sort of broader small super environment. But because of its approved trustee nature, because of that separation of power between trustee and member, it still has such value. And there's been many people over many years that have tried to sort of highlight the key benefits of small APRA from a broader point of view, from an industry position, to say there should be more opportunities for small APRA funds to exist. But most people don't ultimately want that responsibility, because if they can be utilised, and if you go, and I'm not going to make any references to any particular small APRA trustee within the presentation, but if you do your research in this space, they have the capacity to hold property via a small APRA fund. They can basically maintain most of the same investments that an existing self-managed super fund has, and by doing so, you are not going to trigger any CGT or anything like that. So everything remains the same except who the trustee is. So yes, you do have reporting obligations to go to the ATO and say in that instance that you're transferring from a self-managed fund to a small APRA fund, but there's no CGT implications linked to it. And similarly, from a bankruptcy point of view, if that person is then, or when that person is then discharged, they can then be reinstated as trustee of the fund, and the fund can go back from being a small APRA fund to a self-managed superannuation fund. You know, I've always been an advocate of it from a point of view. At one point in time in my super admin life, I did a lot of administration work with small APRA providers, and yes, you certainly had to be a little bit more on top of reporting obligations than you did in the self-managed fund. But now that we've got T-bar and more cloud reporting and those sorts of things, you know, I think the SMSF reporting stuff has caught up to where the small APRA requirements were all those years ago. However, I'm not going to harp on too much about it, just to highlight that winding up isn't the final straw in all circumstances. Even in the worst case scenario of the disqualified party, there is still options available. And so really what this final slide summarizes is that there are options available in most sets of circumstances, and we need to be diligent then when talking with trustees that we're actually addressing, is the wind up the right thing to do? Because once you've done it, that's the end of it. There's no option once you've wound up the fund, it is wound up. So you can't just unwind the wind up as such. So if we look at them, if we go all the way through the various issues, if members and trustees are leaving, we can add new members to the fund. Again, self-managed super funds are indefinitely continuing funds, and so there is no time limit on how long a fund exists for. And if you've got a corporate trustee that sits alongside it, you can add, remove directors of the corporate trustee as you go along. So they are intergenerational in the sense, from a structural point of view. We know investments and balances have to be paid out, but structurally we can keep them going. So again, whether we're talking about members leaving, benefits being paid out, or no longer meeting the needs of the existing members, it may suit the needs of other members coming in, and that's something to be conscious of. The time, skill, and knowledge element that we touched on before, well, you know, there are education offerings out there. Again, people are signing trustee declarations, so they're acknowledging that they do have that capacity to do it, but that might diminish over time. And so then we look at, okay, if education's not enough, maybe we have to look down the path of going to a small APRA fund or some other means in that regard there. If it's not cost effective, why is it not cost effective? Is it your current service provider. So, which, are we charging too much? And when I say, are we charging too much for what the fund represents, we know that people can be quite picky about their fees, and fees are always going to be an issue. Going back in the days when we had checkbooks, and I know they still exist. Found one in my drawer the other day, but and you had your checkbook fees. It was $5 that would come out of the fund, and we had trustees that would complain about that $5 fee. It's like, is a self-managed super fund really right for you if you're going to complain about a $5 checkbook fee? That's why they had the large balances, because they complained about the fees so much. So all these sorts of things, there are always alternates and opportunities for people to look at. If you're going overseas, as I said, you've got the enduring power of attorney concept. You've also got the small APRA concept. If there's a relationship breakdown, you can look to split the superannuation fund. I've seen in one circumstance in my entire time, I've seen one fund that the members remain members of the self-managed superannuation fund. I've heard stories of others as well. I suspect it's probably not ideal, but obviously you can have separate funds, and you can then do the transfer of assets. And then the bankruptcy, you do have that small APRA option. So the only time where there's really no alternative to the wind up is when the ATO direct you to wind up your superannuation fund, and generally your circumstances are going to be such at that point in time from you're ultimately going to be a disqualified person for other reasons there. Then you need to go through the process of winding up the fund. So in that instance, we then need to work out what is that process. What do we actually need to do for winding up the fund? And it is basically a 12-step process. So the wind up element is ultimately 12 steps that we need to go through. And I've put the resources at the back. So I'll put a link to particularly the ATO resources here. So I didn't want to necessarily spend time like putting slide after slide after slide as to what the processes were, rather than to just identify them and then to utilize the resources that you've got the links to be able to work out what is appropriate in your sort of set of circumstances. So clearly the first thing that needs to be done is you need to check the deed of the fund. So what does the deed require? Does a deed have specific clauses about winding it up? Given that the self-managed super fund is a trust, I can guarantee that every deed has some form of instruction as to what is required to wind up the fund. So that's your starting point to determine what needs to be done. Then you need to get a written agreement. And again, what I've done is I've got a copy in here of some of the documents that we use at Smarter SMSF, where basically if the trustees make a decision to wind up the fund, it's got to be all trustees making that decision. And so effectively having a trustee acknowledgement, so having a meeting of trustees, but then getting written consent from the members. So notifying the members. And I know it sounds odd because the members and the trustees are the same people, but we're wearing our different hats. So the trustee writes to the members and said, the trustees have agreed to wind up the fund. Please give us instructions as to where you wish your benefits to be paid. So, if it's if they've got preserved benefits, which super fund they want to pay their benefits to. If they've met a condition of release, then how and where they want the benefits paid. That then triggers the whole selling or transferring of assets. So the next decision to determine is, will we sell these assets and realise a CGT now, or potentially will we look to commence a pension and maybe wind up in 12, 18 months time and progressively sell down the investments to generate the cash and avoid the tax issue there, and then do a cash payout. Fair to say the conversation I had about that in specie one before, the advice that the advisor wanted to give was, because of their age, to start a pension, even though they didn't want the income. By starting a pension, there was going to be a significant tax saving for the fund. So the idea of selling or transferring fund assets, certainly you can do in specie transfers of assets, either to other rollover institutions, certain ones, primarily the retail. I've never seen the industry funds accept it, but a lot of the I guess the managed funds where you've got your portfolios, they will often do the in specie if you've got a portfolio already in your self-managed fund. Finalise any outstanding tax and compliance obligations. So, having that communication with the ATO, paying any outstanding expenses and tax liabilities of the fund, important to make sure that you've got all those issues taken care of. calculating and distributing the member balances. So you want to get to the point where you've determined what all the costs are of the fund, so you know exactly what those final member payouts are. You're not always going to be able to pay the entire amount out, as I said earlier, so you may choose to pay 95%, 99%, whatever it is, to cover off the final liabilities as they fall due. But again, it's a communication piece, communicating with the service providers about whether they'll accept payment in advance. And not too many people I don't know that don't want to receive payments in advance. So, having those conversations as they go along, completing the final audit of the fund, and lodging the final annual return. Of course, there's some critical elements within that final return, so that you notify the wind-up. That then absolves you of your obligation to communicate with the ATO in that regard. That triggers the wind-up process from a regulatory point of view. But what it also does is it removes the supervisory levy from the future year, because we always pay the supervisory levy for the next year. So there's an adjustment done in that tax return to ensure that you're not paying any further supervisory levies at that point in time. Notifying the third parties. So again, making sure that all the parties, whether it be auditors, be it the tax agent, be it actuaries, whoever is involved in it, understands that the fund is being wound up. But importantly, employers, making sure that if the members are in accumulation, that they have communicated with their employers to make contributions to another superannuation fund, right? Because you don't want those contributions not being received in the superannuation system. So that's probably the most critical there. And then the final step after we've lodged the return is to close the super fund bank account. And so I come back to that SuperStream comment that I made before. Ultimately, you will always have that little legacy amount that comes in, or in most instances, you'll have that little legacy amount that comes in. It's a benefit payment, account for that in the previous financials. If it's a rollover, prepare what you need to do to send that money via SuperStream. And I would hazard a guess that it's more important to ensure that last one is a cash transfer rather than an in specie, because you don't want to be left with investments after the end of the financial year. And I guess that's a big issue, is that the timing is critical in all of this. And that was part of the title, is that the SMSF wind-up window is always open. But people often come and say they want to wind up their fund as at 30th of June, and they're coming now in April, and they've got property and they've got other investments that are not easy to sell, collectibles, personal use items, whatever it might be, personal use assets. And so there's an element of longevity in the sell down process there. So we need to, I guess, lower expectations of the time frames around wind-ups, so that people understand that it does take a little bit of time, and then appreciate that you've got record keeping obligations as well. So your accounting records, your financial statements must be retained for 5 years, and your statutory, so your minutes and your declarations and all those other statutory requirements under SIS, that have to be retained for 10 years. So you need to ensure that you've got the appropriate facilities to store the records should the ATO come knocking. So other consideration, and the last real consideration before I wind this up with the checklist that I wanted to show you or work through with you, corporate trustee. So do they want to wind up the company? Because if they want to wind up the company, then they need to again get the timing of that right. I know I fell into this trap. I had a company a number of years ago, and it's like, yeah, I want to wind this up. And every year, my reminder to wind it up was the fact that I kept getting my annual review. And then as I get my annual review, I couldn't, I'd then forget about it or whatever would happen. And so then I'd have to kick it in for another year. And that's a bit of a nuisance process. So you want to make sure that you go through the appropriate steps to wind up that company, if that's the path that you're going to do. But to wind it up, you can do the voluntary deregistration of the company. You've got to meet those conditions there. So everyone must agree, can't be conducting a business, assets less than $1,000, no outstanding liabilities, and no legal proceedings. So as I said before, we can support people with the concept of wind-up documents under our platform, but normally we would have that decision to wind up, then the notification of that decision to the members instruction back to the trustees, and then the final minutes to finalise that actual wind up. So what I just wanted to show you, and I'm not going to go through these sort of check by check, but ultimately, this checklist here, and I've basically got about 20 items on this checklist. The ATO checklist in the resources guide of theirs goes even further, but there's really a whole sort of process that I think it's appropriate for people to work through. And this talks about all those issues that we've just covered off on in today's session. So I think it's a valuable tool to be able to work through all of these key things to make sure that you can sign off on them so that you don't get left with some money sitting in there, and that money and that residual money sits in there too long and you end up with another year's lodgement requirements and other things as well. So just valuable tool to have. As I said, the ATO resources, again, this guide, the Winding Up a Self-Managed Super Fund, which is effectively a consolidation of all of their material, the checklist in there it goes even more comprehensive than what I just provided for you as well. So I think it's a very valuable tool. There was a few years where the ATO actually took down their wind-up guide, which I found to be, problematic, because it's always been a good resource. They do have their fun little video that's probably not a bad one. You send that URL on to your clients to have a look if they want to understand the ATO's position as to why people might actually look to wind up a superannuation fund. So the key takeaways really is, there's lots of considerations prior to the decisions to wind up a super fund, and they might be taxation based, they might be Centrelink based, they obviously could be relationship based and other things. The process itself takes time, so we just need to be mindful that the process does take time. But the key issue is that once it is done, it can't be undone. Yes, the ATO can unwind a cancellation of an ABN just to finalise a process, but it's a nuisance issue. It's not actually a reinstatement issue, so we can't be reinstating under those sorts of circumstances. So the decision is final. So people just need to make sure that they're doing it for the right reason. So look, thank you for attending today. Next month, we're going to talk about insurance and super. I touched already today a little bit on that death benefit, or the future liability deduction. I want to touch on a few of those, particularly in light of such things as DIP 296 and other things. So I've put together a bit of an insurance presentation. I think that brings insurance into the common day sort of thought process. And then in our June webinar, and again, a lot of this is also subject to whether we get too much coming out of the federal budget as well. But in June, I want to run through a number of the key SMSF documentation considerations. And again, I touched a little bit on some of the documents that we have available under Wind Up. So thank you for joining me. I hope you got some value out of the presentation, and I look forward to seeing you all again in May. So have a great day, and I'll see you soon.